Welcome to the ACRL Presents webcast on academic freedom in the digital age. I'm Jennifer Flaxbart, Research and Liaison Services Librarian for the University of Texas Libraries at UT Austin, and the current chair for the ACRL Professional Values Committee. In 1915, the American Association of University Professors, the AAUP, issued its first statement on academic freedom. 100 years later, how do these principles apply in the digital age? With social media firmly entrenched as a communication tool, faculty, librarians, many others have multiple platforms for expression. And recent cases highlight the challenges of extending the traditional protections of academic freedom to the digital world. We're fortunate to have several experts on hand for today's overview and panel discussion of current issues with academic freedom and electronic communication. Hans-Jörg Tiede is Professor of Computer Science at Illinois Wesleyan University. He serves on the National AAUP's Committee A on Academic Freedom Tenure. He recently edited the AAUP's policy manual and authored a book on the founding of the AAUP. Martin Garner is the Dean of the Kramer Family Library at the University of Colorado, Colorado Springs. He has taught professional ethics for the University of Denver's Library and Information Science program since for the last 10 years and has served as chair of the ALA Intellectual Freedom Committee, the ALA Committee on Professional Ethics, and the ACRL Professional Values Committee, or PVC. He's currently serving as a member of the ACRL PVC and is also the Vice President of the Freedom to Read Foundation. Martin is a frequent speaker on ethics and intellectual freedom at state, regional, and national events. A native New Yorker, Martin lives with his husband Mark in beautiful Colorado Springs at the base of Pikes Peak. And Emily Knox is an assistant professor in the Graduate School of Library and Information Science at the University of Illinois at Urbana-Champaign. Her research interests include intellectual freedom and censorship, the intersection of print culture and reading practices, and information ethics and policy. Emily's book, Book Banning in 21st Century America, was published by Rowman and Littlefield in January of 2015. It is the first monograph in the Beta Phi Mu Scholars Series. We have 1 hour together today, and we will cover the following: background on academic freedom and AAUP, current issues with academic freedom and electronic communication, the new ACRL statement on academic freedom, intersections between AAUP and ACRL, and then the panelists will engage with questions from you all, the audience. Finally, we'll offer some further reading and future assistance. And now, I would like to invite Jörg to begin his segment of today's presentation.
Thank you very much, Jennifer. So my presentation is going to be about 15 minutes of giving an overview of principles of academic freedom that the AAUP has established in its policy documents and its investigative work over the last 100 years. And I'm going to give some specific examples of cases, some issues that have arisen lately that also relate directly to the work of librarians. And so I'm hoping that this will be of direct relevance to your work as well. To begin with, We have here a definition of academic freedom. This is a definition that was offered by Committee A on Academic Freedom and Tenure. It's designed to be included verbatim into faculty handbooks or faculty manuals. And I will read the definition, and then much of the rest of the presentation will be concerned with going through the individual parts that are enumerated here in this definition of academic freedom. So academic freedom is the freedom to teach, both in and outside the classroom, to conduct research and to publish the results of those investigations, and to address any matter of institutional policy or action, whether or not as a member of an agency of institutional governance. Let me stop here for a moment, and I will again talk about this in greater detail along the way. But these first three elements that I've enumerated here are very much the core responsibilities of faculty members and librarians as well, which is to teach, to conduct research, and to be involved in matters of institutional governance. And so the first part of this definition of academic freedom states that those activities fall under academic freedom. And then the second part of the definition says that professors should also have the freedom to address the larger community with regard to any matter of social, political, economic, or other interest without institutional discipline or restraint, safe in response to fundamental violations of professional ethics or statements that suggest disciplinary incompetence. Now, clearly, this part of the definition, which is sometimes referred to as extramural utterances, and again, I will talk about this in greater detail later, is the part that also relates to some issues with electronic communication that we will get to in greater detail. Note also that there are some explicit restrictions listed here that are placed on extramural speech, namely safe in response to fundamental violations of professional ethics or statements that suggest disciplinary incompetence. And I will briefly, while I go through the enumeration of these items, discuss ways in which there are limits placed on academic freedom. So on the one hand, there are challenges, but then there are also institutional limits placed that are acceptable, like the ones listed here. Briefly to say, why do we want to have academic freedom? What is the purpose that academic freedom serves? I think it's always important if we want to communicate to other members of the university or the public at large, and advocate for intellectual or academic freedom, to explain what the purpose of academic freedom is. And the 1940 Statement of Principles on Academic Freedom and Tenure, which is the sort of gold standard statement that the AAUP formulated jointly with what is now the AAC and U, provides the following rationale for academic freedom. Institutions of higher education are conducted for the common good and not to further the interest of either the individual teacher or the institution as a whole. The common good depends upon the free search for truth and its free exposition. Academic freedom is essential for these purposes and applies to both teaching and research. Freedom in research is fundamental to the advancement of truth. Academic freedom in its teaching aspect is fundamental for the protection of the rights of the teacher in teaching and of the student to freedom in learning. So this is by way of explanation as a rationale why the AAUP, why I believe the academic community at large believes that academic freedom is essential for the conduct of universities. And so briefly going back to the enumeration that I started out with, academic freedom as promulgated by the AAUP has four constitutive elements: freedom in the classroom, freedom of research and publication, freedom of extramural utterance, and freedom of intramural utterance. And I will go through each one of these four separately. I will briefly describe important aspects of these four elements of academic freedom and some challenges and also some limits, some relevant interests that limit these kinds of freedoms. So the freedom to teach, freedom in the classroom, the freedom to teach extends from such fundamental issues as the choice of course materials, preparation of the syllabus, and the conduct of lectures, to the assignment of grades. All of these directly fall under the concept of freedom in the classroom. But there are limits to freedom in the classroom. So certainly the AUP does not view academic freedom as some kind of unlimited license to do as you please. But for instance, institutional course descriptions, which of course should be the result of a shared governance mechanism by which departments as a whole decide on curricular offerings of the department, and in which the parts of the department that represent certain areas of expertise should have a special voice, yield course descriptions, and these limit academic freedom. So claiming that you can simply teach whatever you want in spite of a course description is, of course, not acceptable. There are of course general ways in which that is not a very clear boundary. Second, disciplinary norms limit this freedom. So there are certain disciplinary norms, say in biology or in physics, that would say you would normally cover this sort of material. And so both of these are in an interplay here in terms of circumscribing the still pretty significant freedom of the individual instructor to make choices about the presentation of the material. Some recent attacks of freedom in the classroom. There was and I will talk specifically about this here on the next slide, there was a proposal at Oberlin that would have required trigger warnings on syllabi and instructed professors to remove triggering material when it does not contribute directly to the course learning goals. This was not enacted at Oberlin, but the AUP subsequently issued a statement on trigger warnings that a representative from the American Library Association also contributed to. And then just to give another example, there was a case not too long ago at the University of Colorado where a sociologist was given the choice to either retire early or remain at the institution, but never again teach a class on deviance that she had regularly taught, just to pick some specific kinds of cases that were in the news in the last year or so. So briefly about trigger warnings, because they are an important current item of discussion. Just to preface this conversation by saying that the claim is certainly not that an individual student who has documented post-traumatic stress disorder who requests a reasonable accommodation under the Americans with Disabilities Act should somehow not receive that accommodation. That is not what the concern about trigger warnings is about. However, the kinds of mandates that the AUP has seen involves administrators instituting a requirement for blanket trigger warnings where instructors have to, from a long list of potential triggering topics, identify any material that might fall under them, which struck the AUP as unreasonable and also as being inconsistent with academic freedom. And more generally, and this is a quote from the report, trigger warnings single out politically controversial topics like sex, class, race, capitalism, colonialism for attention. And if we associate them with triggers, correctly or not, they are likely to be marginalized. And so this is the part where this raises concerns about academic freedom, because it will ultimately, or it can ultimately, lead to the suppression of certain kinds of topics from the syllabus. Freedom of research and publication. The freedom to pursue research and publish results is obviously fundamental to academic freedom. Historically, different fields have come under scrutiny. Economics 100 years ago, social sciences 100 years ago, and still today, as you saw in sociology, area studies, ethnic studies, and gender studies have come under scrutiny. So those are areas where freedom of research is at times threatened. There are other challenges to this freedom, for example, having external funding agreements that limit publication. Institutional review boards are a limit. They limit freedom of research, and we can have arguments over whether that's a good or a bad thing, but there are aspects to the institutional review boards that the AUP has also criticized as being problematic. Professional ethics and disciplinary norms, including peer review, limit freedom of research and publication. The peer review turns down a submission that is not a violation of academic freedom, because peer review, again, is part of the disciplinary norms of publishing. Intramural utterance is what we would identify as speech that refers to matters of institutional governance. So if you, either as a member of your institution, as a faculty member or as an employee of the institution, criticize the conduct of the administration or the conduct of a governance body, then that is an example of intramural speech. The AUP has pointed out specifically that it is important to safeguard intramural speech in your faculty handbook or other kinds of documents on your campus because of a Supreme Court decision, which is the Garcetti ruling. And I won't go into the details here right now, but simply to say there are concerns that faculty at public universities could find themselves not extended First Amendment protections because of this ruling, which is still, some aspects of this is still making their way through the courts at this point. In any event, simply briefly to mention that it is important to have a separate statement in your faculty handbook safeguarding intramural speech. And finally, extramural speech, as I said, is the freedom to address the larger community with regard to any matter of social, political, economic, or other interest. Interestingly, that is an aspect of academic freedom unique to the United States. It very much arose 100 years ago because of the political and social circumstances of the progressive era that led to the founding of the AUP, and it's been a constitutive element of academic freedom in this country ever since. It is also the most controversial aspect of academic freedom, as it is not necessarily related to disciplinary expertise. And so a recent challenge to academic freedom, especially to extramural utterance, has been this issue of civility. There have been a number of cases where a faculty member, Stephen Salida at the University of Illinois, was not appointed because it was claimed that his tweets had been uncivil, and there have been some other cases of faculty members who have been accused of incivility online, and the AUP has spoken out against using civility standards in assessing extramural utterances. And the Committee A on Academic Freedom and Tenure noted several decades ago that some may seek to defend the distinction between the regulation of the content of speech and the regulation of the manner or style of speech, but Committee A finds this distinction untenable in practice because offensive style opprobrious phrases may in fact have been chosen precisely for their expressive power. And with that, I will turn it over to Martin, who will continue from here.
All right, York, thanks for that great introduction. And we will talk a little bit more about the Red Book later on. What we want to do at this point is just talk briefly about some of the ways that electronic communications in particular are coming under scrutiny with respect to academic freedom. I had the opportunity to participate in the revision of the statement on academic freedom and electronic communications that was originally issued in 2004 by the AAUP and was updated in 2013, primarily to deal with issues related to social media. And like other policy statements, and this is a rather in-depth one, 16 pages worth to read, it does give recommendations to institutions and to faculty on how to best handle things like social media. For example, it does make the strong case that when it comes to social media statements, whether it's Twitter or Facebook or pick your platform, that these platforms can be used to make extramural utterances, and therefore they should be treated with the same protection as any other extramural utterance under academic freedom principles. And so this is trying to, again, state the case for why we should be able to expect the same freedoms when we're using these platforms as we do using traditional platforms such as writing letters to the editor or making speeches outside of the classroom. One thing to keep in mind is that this is guidance, and so it's important. The statement does say that it's important for faculty to be involved with the development of policies that address these issues at their own institutions. And there have been cases where policies have been proposed that would have violated these principles, and the AAUP has spoken out against this, but it's important for faculty to also raise the alarm if they see something that's of a concern. We had a program that talked a little bit about this at the ALA annual conference, and a question that came up at the audience at the time was, well, if I'm doing this on my personal account, should it really have nothing to do with my employer? And it's important to know that there have been cases where faculty members have either been reprimanded or even dismissed for statements that were made outside of their institutional affiliation, even with disclaimers saying that this is my personal opinion and does in no way should be construed to represent the opinions of my employers. Now, again, if you are in a position where you are a tenured faculty member or have other expectations to academic freedom, you may have a stronger case in defending yourself, but it's something to keep in mind that this has happened elsewhere. So it's these are troubling times. We've made reference already to some of the issues that have brought this issue to the fore. Stephen Salida was mentioned by York as someone who had used his personal Twitter account to make a number of statements about the situation in Israel and Palestine, and his appointment was rescinded by the chancellor at University of Illinois, who is no longer the chancellor. And there is a lawsuit that is still underway, so we will see what happens with that. And of course, the tricky thing here is that you had someone who was a tenured professor and was not quite yet a tenured professor at his new institution, and so that's the loophole that's being exploited in this case. Another case is of John McAdams at Marquette University, who on his blog expressed some opinions about a graduate student and the student's handling of a controversial topic in a class. And this student was not one of his students, but he disagreed with her approach on that. He felt that she was stifling student speech when it came to some controversial topics, and wrote a rather spirited blog about it. And it caused a great deal of scrutiny to be placed on the grad student, threatening emails, disparaging comments, to the point where she felt it was necessary for her to leave the university. And ultimately, at this point, the case is still ongoing. McAdams has been suspended, but there's a concern that because he exercised his right to speak his opinion about this, though, again, perhaps with using some uncivil language if we're going to get into the civility thing, there are concerns that this is yet another encroachment on academic freedom. Finally, Laura Kipnis at Northwestern had a slightly different type of investigation that involved Title IX, based on an essay that she published in the Chronicle of Higher Education. And so this is not quite coming to social media, but just another example of how an extramural utterance can still cause challenges for the people who are making them. In her case, she was describing university policies governing sexual misconduct, and talked about some lawsuits between a Northwestern philosophy professor and 2 students who had accused the professor of sexual assault. And students took some issue with her essay and actually made a complaint using the Title IX process. So it was interesting that instead of having administrators who were investigating this is actually something that was started by the students. And ultimately she was cleared of this, but again, it just illustrates some of the challenges that free speech faces at this point. Now, in light of all of these things, the ACRL Professional Values Committee was thinking about ways that we as librarians and as academic librarians in particular could offer our support to faculty members who are, in this case, all 3 cases, not in the library for their in support of free speech. And while ACRL had some statements that talked about the importance of academic freedom for librarians and also related to the how advocating for librarians to have the same protections as other faculty when it comes to academic freedom, there was no statement that talked about our just pure support for academic freedom period. And so over the place of a year, we drafted a statement that went through a review process and came up with got some great feedback from members at ACRL, and then it ultimately was approved this past June by the board of directors. The statement is on your screen. I'm not going to read it to you, but you can kind of get the gist of it there. That talks about that we not only support academic freedom for all librarians and for faculty on campus and in all contexts. And so trying to make sure that this is a statement that we can draw upon in the future. As you may know, both ACRL and ALA tend to focus when it comes on controversies on making statements about the general principles rather than about individual circumstances. So that way there can be a quick response, so that if, say, tomorrow there was a case where academic freedom was under assault and ACRL wanted to be able to point to something or was asked what their opinion was on something, they could point to the statement and say this is a matter of policy, that we support academic freedom, that we oppose retaliation, and states our principles here. So this is kind of a big step for us, because we're going beyond advocating just for the rights of librarians, but also for our colleagues in the classroom. So what we want to do now is talk a little bit about what are some of the commonalities that AAUP and ACRL have in common. That's what commonality is, sorry about that. But to talk about those places where we've worked together. And so one of the statements I was referring to before is actually a joint statement between AAUP and ACRL. It is the Joint Statement on Faculty Status of College and University Librarians. In both cases advocating for as much of the faculty privileges that can be extended to librarians as we should expect to have, keeping in mind that the status of librarians in academic libraries is a mixed bag across the country. So that's one joint statement that we do have together. We have also, as ACRL and as ALA, have endorsed the AAUP Statement on Academic Freedom and Tenure, and the AAUP likewise has endorsed our Intellectual Freedom Principles for Academic Libraries, which is an interpretation of the Library Bill of Rights. That's what that little abbreviation is for. And as York mentioned earlier, with the trigger warning statement, we were able to provide some input to that, and ACRL did endorse that as well. And so there is a long history of these two organizations working together so that we can, when we find a common purpose, that we can put our voices together, because it does sometimes bring together two groups that don't always, aren't always in each other's radar. So And York, I want to give you an opportunity at this point, if you have other examples or other things that you want to mention. That, we've had a couple of conversations, and you were able to meet with some of the folks at the American Library Association and the Office for Intellectual Freedom to mention any other areas where AAUP and the library profession either have worked together or might, other possible shared concerns.
Thank you. So I guess I would mention that, as I mentioned before, I currently serve as a member of Committee A on Academic Freedom and Tenure, and for the last several years, Barbara Jones, who is in the Office of Intellectual Freedom, has been a consultant to that committee, and so it's been really important, I think, for us to have a ready presence of librarians' concerns on the committee, which I think is, I believe, one of the reasons why Martin, you were then subsequently involved in drafting the statement on electronic communication, and which in turn is why the trigger warning statement came to the ACRL. So I think it's been a good way of making sure that we've been aware of each other's work, and I think that would be a particularly important thing to continue to do and to continue to bring to the attention of the membership of both organizations, as we're doing here right now.
All right. So at this point, what we wanted to do, and I'm going to pass the torch over to Jennifer so that she has this control going forward, is turn it over to some questions. So Jennifer, I'll let you take it from here.
Thank you. Now that you've all heard from York and Martin, I'm wondering what your questions are. Please submit them in the chat window. And I'll ask Margot to assist me here as well.
And this is also a chance for Emily to be chiming in, who has graciously agreed to be another respondent for this part of the session. So feel free to ask it for any one of us who are here on the panel.
I didn't mention it earlier, and I want to thank Emily for being the vice chair for the Professional Values Committee. She and Martin have been instrumental in working together to move initiatives forward. So please do. Now that these individuals are available, ask your questions.
Maybe I don't know if we're just going to take these, since I see there's a question here by Julia Nims about trigger warnings. So I'll try to answer that one. So the question is, I have this in the Q&A chat box. We seem to have two different chat boxes. It asks about trigger warnings. Is the objection that they are required, or is it the actual content of the statements on the syllabi? So I think the statement, the AAUP statement, addressed those separately. There's a strong objection of the AAUP to require them, so to have administrators or faculty committees, for that matter, mandate faculty to provide them, again, in this blanket general form. More specifically, I think the statement argues that there's a case to be made that an individual just providing them voluntarily, that may not be a good idea. And I don't want to get into the full details of that, but simply to say, it makes an argument simply on pedagogical grounds, the statement on trigger warnings, that may not be a good idea. But certainly, the AAUP is not in a position to say to individual faculty members that they shouldn't provide them if they so choose.
So previous to that, Emily Gorman asked, can you please expand more on how libraries could handle social media accounts posts with regards to intellectual freedom and academic freedom, especially dealing with controversial topics? I guess I'm not sure if this means for the library's individual account or for someone's, for the library's institutional account or for someone's individual account. So that I would just need to have that a little bit clarified.
Maybe until it gets clarified, I could address. So I'll talk briefly about the next question, and then maybe if by the time we get some clarification, Emily, you can go back to that perhaps. The next question is about university implementing mandated learning outcomes for programs and courses. How does that fit in with the freedom to teach, develop syllabi, et cetera, in the classroom? So the AUP has a separate statement on mandated learning outcomes. I mean, I would say in general, to some extent, it's a similar answer as to course descriptions, in that they need to be the product of the faculty being involved in shaping these kinds of learning outcomes. So they certainly cannot be mandated from the outside. Now, there are issues about accreditation, especially accreditation in certain kinds of majors. And again, that's where there would be a give and take. But sort of the broad scope general answer is that yes, learning outcomes can limit, just like course descriptions, the freedom to teach, but they should be the product of the faculty collectively making decisions rather than simply being imposed.
There's another question about how the statement's been received by faculty and librarians. Any feedback? I know we just got to see that recently, so I'll ask my fellow committee members if they've heard any feedback specifically about the statements.
I have not. I'm not aware of any formal responses from anywhere. There were informal notes of appreciation and remarks of appreciation made once the statement was approved by the board back in June, but I haven't seen any formal response at that point. Jennifer, how about you?
No, I haven't heard anything subsequently. So I know we were inclusive, as inclusive as we could be in gathering input from various constituencies. And so I think people were happy to see that move forward and solidified.
I'm happy to move to the next question by Stephen Bell. Have there been any challenges to materials acquired by academic librarians on behalf of the institution? For example, a challenge that the book is too controversial, biased, etc. If that did happen or were to happen, wouldn't selections be covered by academic freedom? So I'm not, my colleagues my librarian colleagues will be better able to answer the question of to what extent there have been such challenges recently. But yes, clearly that would be an academic freedom issue, and that's certainly one of the many reasons why why librarians should have faculty status and should have, ultimately the protections of tenure, is that these are the kinds of academic freedom issues that librarians face, and so yes, the answer would be yes.
This is Emily. I actually study challenges. That's my main area of focus for my research, and it's very difficult to find out about academic challenges to materials in academic libraries. Actually, I would encourage you to get in touch with me. My email is knox@illinois.edu if you have experienced a challenge. I teach a class on intellectual freedom, and many of my students are interested in how to respond to such challenges. It seems that they are sometimes, the ones that I do know about are often about things like junk science or something like creationism in the library. And I always encourage people to make sure that they update their collection development policies, and that all academic libraries should also have a reconsideration policy. And yes, those selections will be covered by academic freedom, but because you're working with a particular audience, I think it's important to still allow people to register any concerns they might have on the collection. But other members of the committee can also answer.
You know, it's funny because I was just in a meeting the other day where the absence of a formal policy regarding challenges and requests for reconsideration came up, and the statement was made that I think is a belief that's held by many academic librarians is that, well, we just don't get challenges. And someone else pointed out, well, in fact, we did have someone who had requested a book be moved from one section of the collection to another because it was a psychology book that drew upon a very spiritual approach to dealing with some trauma, and the person felt it was better off in the religion section. And in response, the original person who said, well, we don't have challenges, said, well, actually, we've had, well, that's a classification issue. That's not a challenge. And I would say, well, in fact, you know, they are saying something about the content of the material. So I would echo Emily's point about making sure that this is addressed in your policy, or even to adopt a policy if you don't have one, because it's something that I think too many academic libraries just assume is not going to come to them. And if you don't have a policy in place, then you're opening yourself up for all sorts of issues when something does come up and then it goes over your head because you've got no formal way for handling it.
Emily Gorman has offered clarification for her question about expanding on how libraries could handle social media accounts and posts with regards to intellectual and academic freedom. She was referring specifically to institutional accounts. Does anybody have any advice for Emily on that question?
I mean, sorry, this goes back to the original question about how to handle social and media accounts posts with regards to intellectual freedom. I guess my only answer would be, you know, what the statement that Martin was involved in drafting pointed out. I mean, which is it should be considered extramural utterances. And so, you know, I mean, from the perspective of faculty using them, it should be, you know, part of their freedom of extramural utterance.
So I would say from a, go ahead.
No, go ahead. You read first, so you go first.
I would say from a practical point of view, so to me, this is part of community relations when it comes to institutional accounts in particular. I would say that you should be aware that if you do say something that's controversial, that you might receive some sort of pushback on it. So you have to decide how much political capital you want to expend to do that. And different institutions, different people will have different ideas about how much they want to take on. I don't think there's any one answer for that. Different people are, and different institutions are in different places and different communities. So answering that question is rather difficult. You sort of have to decide what sort of stance you would like to take.
I think another thing to consider here, and I'm not sure if this is part of your question or not, is how libraries may deal with things that are posted onto their pages or accounts. And so there, a lot of libraries have had to figure out how to handle, is it censorship if you delete a comment that has vulgarity from the library's blog? And the guidance to this point has been to have clear rules of behavior that you would have on any sort of open forum, and that it's when the library is actually the host of the material, then you have there's a different level of responsibility and control that's allowed, because you may not think that it's appropriate for the library's website to have profanity on it, for example, unless you want it to. And so therefore, if you have policies in which you might have a firmer control on what's being posted on the library's institutional accounts, as long as those guidelines are laid out clearly and it's understood that these are the official pronouncements of the institution and not just an open forum for free speech, which can be done elsewhere in the library. That seems to be the guidance that's going out at this point. I'm not sure if that was part of the question or not, but.
There was another question posed by Louise Sherby. She indicates that in today's Inside Higher Education, there was an article about loyalty oaths in Arizona and a faculty member who refused to sign it and will resign. Does this fit into academic freedom?
So yes, I mean, loyalty oaths, it's very funny that they're coming back. I guess they actually are still on the books from the McCarthy era. I read the headline this morning. I have not further investigated what actually the content there is, but they are certainly an infringement on academic freedom, and you know, have been condemned by the AUP and others, certainly by the American Federation of Teachers, since they started showing up actually in the 1930s. There is a question by Courtney. I'm sorry, maybe somebody else wants to weigh in on the loyalty oath issue before I move on.
I think you covered it.
There's a question by Courtney about librarians working with library assistants who don't have the same protections we do have in terms of academic freedom. And again, you know, I will just briefly say something more generally. There's a whole category, of course, of employees that the AUP categorizes as academic professionals. So the AUP also provides some guidance for how you know, the rights of academic professionals who don't have faculty rank should be safeguarded. Just to say, in general, I mean, the AUP believes that the best protection for academic freedom is tenure. But you know, short of tenure, there needs to be at least some level of due process provided to anybody. So to you know, library assistants if they are academic professionals or others who don't have tenured status, to make sure that they can have a review of any adverse personnel decision against them, whether those be you know, up to and including dismissals, to make sure that their academic freedom is safeguarded. So I will simply point to the AUP's longstanding tradition in defending also academic freedom of others, including academic professionals.
There's also a question about the Tor project and anonymity. Is this something that needs to be addressed, or is this considered more of a public library issue, or is this more aligned with intellectual freedom, not academic freedom?
I have to admit I'm not familiar with the Tor project, so I can't speak to it.
It's an anonymous, essentially anonymous way to browse online.
Yeah,
so I have my own thoughts, but I'm curious as to what other people have to say who are working currently in libraries.
Right. You know, I can see. You know, I know that there was the case, I think it was a library in New Hampshire that had basically signed up to do this and then took a break or paused when people raised some concerns about it. And there was actually some discussions with law enforcement, and then they went ahead and decided to do this. I think in public libraries, in this case, might actually have it a little bit easier to do this because they are more independent. And I can imagine the conversations that many academic libraries would have with their institutional information technology departments over some of the security concerns that we have or that they might bring up with anonymous browsing. Having said that, I think that it's still the library's responsibility to advocate for acceptable use policies within their institutions that safeguard the privacy and confidentiality of all users on campus to the greatest extent possible. There are a lot of times where we're left out of the conversation altogether, but I would think we do have a responsibility to say what our principles are and try to get them into the policies that we can. Sadly, I think that because we tend to be enthralled to external IT departments, in many cases, this may not be an area where we'll get a lot of traction. That's my personal thought.
And I think, Martin, that actually is very much also in line with the recommendations in the statement on electronic communication that you were involved in, which I think makes it clear that sort of acceptable use policies or IT policies, to the extent that they relate to academic mission of the university in the broadest sense, there needs to be involvement of faculty and academic professionals in drafting them, so that is not something that should just be happening in a vacuum without input.
Yeah, and I would also say that this could also be approached from the other way, which is letting students, faculty, staff know that their browsing habits are not anonymous online. So actually using it as an education tool, even if you're not going to use the actual Tor project itself, but just to let people know that there have been disclosures about things happening at NSA, that when they are using campus networks, that those might be monitored. I would see it more as whether or not you can actually install something that makes something private to actually use it as an education tool.
I think we've addressed the questions that are currently in the queue. Does anyone else have another question?
Well, I do see a couple of follow-ups, and I'm not sure about you, but I've only been seeing some of the questions, so I think that they're not always getting directed to everybody. There was a little bit of one thing I wanted to follow up on about the question about library assistance and whether or not, what our role is with that. I think it is important to know that the NLRB, the National Labor Relations Board, has ruled that when it comes to social media, there are certain actions that are still protected by them, so that if you have a conversation on your Facebook page with other employees about working conditions and talking about ways that you could advocate to change them, that is working in a concerted effort to improve conditions, and that's protected. If you make derogatory statements about your boss just kind of in general and are complaining about things with no specific audience, that's not going to be protected. And unfortunately, when it comes to employees who do not have faculty status, there are very strict restrictions on free speech in the workplace. And I'll put on my ALA ethics hat and direct you to a Q&A document on speech in the workplace that addresses a lot of those issues. And then I did see there is another question that came up about academic freedom related to research, including the freedom to research outside the realm. And I can think of a case of an institution that said within their librarians who had advanced degrees in other areas and had been doing research in those other areas, that it did not count. It was no longer going to count towards their tenure and promotion process as being acceptable publications because it was outside of the area of their expertise. And I know that in a lot of cases that will depend on what your own faculty handbooks might say. You know, I think that it's not a matter of academic freedom to say if you're being prohibited from publishing your article on migrating birds, for example, that would be obviously a violation of academic freedom. I think the question is, can you do this research that is not necessarily directly related to your job and then have it count towards promotion in your job? And I would ask that question of in any academic field. You know, Emily, for example, you know, you're on the tenure track. If you published a peer-reviewed article on quantum physics, and I don't even know what else to say about quantum physics. I know nothing about it. You know, would that count towards your progress since it's outside of your discipline?
Probably not. I mean, I think this is where it gets a little sticky, because I think what actually people think about is issues that are a concern to them that are outside of their actual area of research. So say like your main area of research is, say, on information seeking, but you also want to study something about like serving diverse populations, right? Would that be covered under academic freedom? I think it would be covered under academic freedom, although I might be wrong on that. But it goes into all these other issues of whether or not you'll be seen as an expert on it, whether or not your committee will give you, you know, tenure based on it. I think that so thinking about whether or not something is covered under academic freedom, it's often things are, but will they actually help you in your process is not always the same question, I think is what we're saying.
Yeah. Yeah. So, I mean, ultimately, you know, people have the freedom to research whatever they want. And I think the question is whether or not that should then count towards towards your job requirements. I think that's really tricky. If you're told that you cannot look into those issues at all, even on your own time, then I would say that's definitely a violation of academic freedom.
Yes.
And I would agree with that. I think the question of academic freedom is just one that's related particularly to adverse job actions, like being fired, being sanctioned in some manner. That's where it's a question of academic freedom. But again, peer review, for example, is at the heart of tenure, and so you know, there are cases where tenure decisions have an element of discrimination or academic freedom violations. But depending on exactly what the relevant regulations say, in this case, it may not be a violation of academic freedom.
We're coming to the end of our time. There's one final question that we might be able to address, and then perhaps we can move on to some additional resource information to close for today. The remaining question is about blog posts and ensuing lawsuits that have had a chilling effect on academic librarians expressing their professional views through extramural utterances. And where do we go from there?
Right. You know, in the case, you know, these are, in both cases, these are librarians who have expressed, I would even classify, I would say that this is even extramural because, well, I'll just leave that alone. This is part of their professional work where they are either expressing their professional opinion about a publisher, in the case of Dale Askey, or in Jeffrey Beal's case, you know, doing his somewhat controversial ranking of and listing of predatory open access journals. You know, it's great to know that, you know, at least in Jeffrey's case, that his institution is behind him 100% and that he's getting support from the attorneys. I think that it is a big concern that we might find ourselves afraid to offer our professional judgment on the quality of resources if we think we're going to be hit with lawsuits. you know, the good news is that, at least in the United States, we have greater protection than some of the libel tourism that we might see for folks who are based outside of that, outside of this country, and that's the case with Dale Askey. But I think that it is, it's something that should be on our minds.
The only thing to add is, I mean, the AUP has recommended that institutions provide legal protection to, you know, faculty members, and so this certainly, it should be as a matter of course that somebody who is expressing their professional opinion and is being sued in this manner should receive legal assistance from the university.
I want to point out that we have the screen, the resources now on the screen. AAUP, the Red Book that was touched upon briefly, the ACRL Professional Values Committee link, and information from the ALA Office for Intellectual Freedom. I'd like to thank ACRL and our panelists, York, Martin, and Emily, for all of their insights. Thank you for attending today's webcast, and I think that I will invite any final comments from our panelists and say farewell.
Thank you very much.
Yes, thank you.
Yes, and I want to point out that this was one of the things, when the Professional Values Committee was first formed, we did a survey and asked members what they wanted from us, and one of the things was online education opportunities about topics related to intellectual freedom. So we listened, and here we are, and we hope to be doing this again in the future.
Thank you again.
Thank you.